Today we are going to see block number 3, unit number 13, demotion and discharge. Introduction. Demotion is just opposite to promotion. In demotion, the employee is shifted to a job lower in status, grade, and responsibilities. Demotion refers to the lowering down of the status, salary, and responsibilities of an employee. In the other words of Dale Yoder, demotion is a shift to a position in which responsibilities are decreased. Promotion is in a sense an increase in rank, and demotion is decrease in rank. When an employee is demoted, his pride suffers a more severe jolt than it does when he is superseded by his junior. Some managers hesitate to demote a man. They prefer to discharge him rather than to demote him on the lower job because he will not accept the lower job and will turn to be a disgruntled employee, and his position will not be good for better industrial relations. Discharge. Discharge is nothing but the termination of the services of an employee, but it is not done for the punishment purpose. Dismissal is nothing but the termination of the services of an employee to give him punishment for his misconduct in the organization. It is a permanent separation of a worker from work. It is a termination of his employment and may be either the result of some disciplinary action or retrenchment of surplus labor. Thus, a discharge involves permanent separation of an employee from the payroll for violation of company rules and for inadequate performance. It is initiated by the management, but today it is not a prerogative of employer to discharge the employee due to legal provisions and strong trade unions. Causes of demotion. Inadequacy on the part of employees in terms of job performance, attitude, and capability. It happens when an employee finds it difficult to meet job requirement standards. Following is promotion. Demotion may result from organizational staff reductions. Due to adverse business conditions, organizations may decide to lay off some and downgrade some jobs. Demotions may be used as disciplinary tools against errant employees. If there is a mistake in staffing, that is, a person is promoted wrongly. When, because of a change in technology, methods, and practices, whole hands are unable to adjust, or when employees, because of ill health or personal reasons, cannot do their job properly. Demotion policy. Demotion is very harmful for the employee's morale. It is an extremely painful action impairing relation between people permanently. While effecting demotions, a manager should be extremely careful not to place himself on the wrong side of the fence. It is therefore necessary to formulate a demotion policy so that there may be no grievance on the part of the trade unions. Number 1. A clear list of rules along with punishable offences may be made available to all the employees. Number 2. Any violation may be investigated thoroughly by a competent authority. Number 3. In case of any violations, it is better to state the reasons for taking such a punitive step clearly and elaborately. Once violations are proved, there should be a consistent and equitable application of the penalty, and there should be enough room for review. Types of demotion. Voluntary demotion. As the name itself signifies, a permanent employee of the firm can make an application for a willful demotion to a vacant position of lower grade, provided the employee has attained the permanent status in that particular class, or the request of demotion is to a related class in a similar job series. Involuntary demotion. Involuntary demotion is nothing but is a disciplinary action and is subject to disciplinary positions and procedures. And the following are the reasons for the demotion. Number 1. Inefficiency. When an employee gets a promotion on the basis of seniority and past performance, but he proves to be incompetent in performing tasks related to that post, he or she thinks it is difficult to reach performance standards. Hence, the management demotes these employees back to the job in which their capabilities, aptitude, and knowledge match the job requirements. Adverse business condition. It may also be due to adverse business conditions. The following may cover: closure of some departments or plants, withdrawal of some products, reduction in quality of production. In such cases, freshly recruited employees or lower level employees may be laid off, while the retrenched and senior employees may be demoted. Change in technology. When there is a change in technology, method, or technique, there is a need for new or higher level skills to perform the job. And if the employees who are working currently in the organization do not upgrade themselves with the emerging requirement, then the company's management demotes the employees to lower ranks where they can fit suitably. Next, administrative convenience. Because of external developments or internal reconstruction, an organization is bound to eliminate certain positions or merge them for administrative purposes. In these cases, the incumbents of merged or eliminated positions may be moved to lower ranks. In such situations, organizations prefer demotion as a better alternative to layoff when the reduction of staff becomes necessary. Disciplinary action. A firm may also demote employees as a result of disciplinary action, but only a few organizations practice it. That is to say, the organizations practice this as a punishment for employees for serious breaches of rules and regulations and for continuous poor performance. Basically, demotion is a less severe punishment in comparison to the dismissal or discharge of employees. But employee unions strongly condemned it because it has a very negative impact on the mental and emotional health of the employees. Principles of demotion policy. Demotion policy principles. Demotion policy must rest upon some sound principles like: number 1, state clearly the list of circumstances under which an employee will get a demotion. Specify the authority which is the responsibility to initiate the process of demotion. Next, to clearly state that the nature of demotion, that is, if it is permanent or temporary. Next, mention the jobs from which and to which demotions is going to happen. The firm must specify the criteria for demoting employees, that is to say, who will be demoted first: a person whose length of service is not more than 1 year or whose performance is poor. A prior and clear declaration of demotion policy should be mentioned. Mention clearly the relevant authority who is responsible to investigate any violation of demotion principles. On identification of violation, the penalty that it may attract should be specified. There should be clear norms to appraise the merit and length of service of employees. Discharge of employees. It is occasionally necessary for the university to discipline suspended and to discharge an employee. Reasons for discipline up to and possibly including immediate termination include but are not limited to: violation of university or departmental policy rules conduct, failure to properly perform assignments as determined by the university, poor performance, dishonesty, theft, drinking alcoholic beverage on the job, etc. Use of drugs in violation of the Controlled Substances Act, including marijuana as defined by federal law. Insubordination, conduct unbecoming of a university employee, retaliation and adverse action against an employee to punish them for engaging in legal protected activity, conduct on or off the job site that impairs the employee's ability to perform their job duties. Since situations vary, supervisors must consult with the human resource prior to initiating any formal disciplinary action, including suspension or termination. Human resources will assist supervisors to ensure the consistent interpretation of current policies, procedures, contractual obligations, or precedents set by the university. Steps of disciplinary policies. Progressive discipline policies also have the advantage of setting up the standards by which all the employees are treated and thus ensuring a level of consistency in the disciplinary process. The standard progressive disciplinary policy has the following steps. Number 1, verbal warning. Number 2, written warning. Number 3, suspension or final written warning. Number 4, termination. Dismissal. Dismissal for just cause can only be established if there has been a fundamental breach of the terms of the employment contract. In cases of termination for just cause, an employee may be dismissed without notice or pay in lieu of notice. However, whether an employee may be dismissed immediately for misconduct will depend on the nature of the conduct. In most instances, the misconduct may be objectively significant and not trifling, and the employee will have to be warned of the consequences of future infractions before an employer may terminate the employee for just cause. Causes of discharge: incompetence. Normally, an employee will have to warn an employee of their failure to meet acceptable standards, set out the standards that are expected, and given an employee a reasonable time to improve. An employer will also have to provide the necessary support or training before terminating them for incompetence. If the failure to meet the standards is not the fault of the employee or there are mitigating circumstances, an employer will not be able to rely on incompetence as a basis for termination. Conduct outside normal working hours. Normally, an employee's conduct outside of normal working hours will not constitute grounds to terminate the employee for just cause unless the employee can establish the employee's conduct is wholly incompatible with the employee's discharge of his duties for the employer or causes damage to the employee's reputation. Harassment and sexual harassment. Most employers now have harassment policies which caution employees that a violation may result in the termination of the employment. As with other types of misconduct, a decision as to whether to terminate for just cause will depend on the factors such as the nature of the misconduct, whether the employee shows remorse and length of the service of the employee, whether the employee has been disciplined for similar conduct in the past. Dishonesty. The Supreme Court of Canada has held that in determining whether just cause for termination on the basis of dishonesty exists, the employer must have regard to the nature of the businesses, the level of seriousness of the dishonesty, as well as its impact on the employer's business. Disobedience in subordination. If an employee regularly uses language which is inconsistent with the employment relationship or refuses to respect the authority of management, the employer may have grounds to terminate for just cause. This is also a situation where progressive discipline should be used prior to termination. It is also recommended that you find out from the employee whether there is any other factor causing the defiant behavior before making a decision to terminate. One act of disobedience will not normally give rise to grounds for termination, of course. However, if there is a repeated failure to follow the employer's direction, policies, or procedures, grounds for termination for just cause may exist, and employers should be ensured that any directions given to the employees are clear and unequivocal. Revelation of character. If an employee has engaged in behavior which shows that he is an untrustworthy character, an employer may have grounds to terminate for just cause, especially in situations where an employee is in a position of trust. Lateness and absenteeism. Employers must be able to satisfy a code that the employee's level of absenteeism far exceeds that of the average employee and that there is no reasonable expectation that the level of attendance will improve in the future. Absenteeism because of a disability will not normally be the grounds for termination for cause. However, even when employees are absent because of the disability, employees are entitled to a reasonable amount of information confirming that the employee is unable to attend work because of illness or accident, that they are undergoing treatment, and whether they are likely to return in the future. When calculating the level of absenteeism, it is important not to include leaves of absence permitted by the statute, such as maternity leave, family medical emergency, and jury conduct duty. Employers are cautioned to seek legal advice before terminating anyone based on a frustration of contract because of absenteeism. Alcohol or drug use. Alcohol or drug use during working hours is certainly grounds for discipline and may be of grounds of termination of just cause depending on the impact upon the employee's business. However, addiction to drugs or alcohol is considered a disability, and thus an employer has an obligation to accommodate these abilities by at minimum but giving employees a leave of absence to seek treatment. Conflict of interest. Employees have an obligation to avoid actual or potential conflicts of interest in the course of their employment. Some conflicts are of serious as to justify immediate dismissal for cause. For example, if an employee were to carry on and divert business in direct competition with the employer, a fundamental breach of contract would likely be established. Disciplinary demotion. In a non union situation, an employer has no right to discipline by demoting the employee unless it is a term of employee's contract that he or she is subject to demotion for misconduct. Condemnation. One of the biggest impediments to arguing a successful case for just cause, it is the doctrine of condemnation. If an employer has allowed an employee to engage in misconduct repeatedly without taking any steps to address and remedy the misconduct, it can be argued that the employer has condoned the misconduct. In this event, an employer will have to re establish the standards of behavior, clearly communicate them to the employee, and give the employee an opportunity to mend his or her ways before termination. Constructive discharge. Encouraging an employee to resign or retire early rather than be fired may seem like an effective means to avoid potential problems. However, forcing a resignation by telling the employee to resign or to be fired, or by making working conditions so difficult that a reasonable person would be perceive the situation as intolerable, does not avoid potential legal issues, it may exacerbate them. In absence, by pushing someone out by an employer effectively discharges him and still remains vulnerable to potential discrimination charges. Note that state standards differ considerably, and some states address constructive discharge issues through statute. Thank you.